Well, thank you for joining us today. Would one of you kindly remind our viewers what you're running for?
County Court Judge, Seminole County, Group 6.
Okay, thank you. And we always start these proceedings with some routine questions, so we'll get to it. With Mr. Finch, to begin with, have you ever been arrested, sir?
No.
Okay. Judge?
No.
And Ms. Rivera?
No, sir.
And we'll start this way. Ms. Rivera, have you ever declared bankruptcy?
Yes.
Okay, can you tell us the circumstances of that, please?
Yes. I was previously married, and when my husband at the time left, it left me in a position to fend basically for myself. I had a child at the time, and we had a home. So the financial situation being what it was, that was my option.
Okay.
And what year was that?
That was in 2009.
Okay. Judge Collins?
No.
Okay.
No.
And Mr. Finch, have you declared bankruptcy?
Yes.
And could you tell us the circumstances of that?
It was a product of a divorce. It happened in 1999, I believe. I think it's final in 2000. I'm not real sure. It's a long time ago. And it was a result of a divorce, two people moving toward a common goal, and then neither person moving toward that common goal. It was a difficult time in my life. So.
All right. Well, we'll move on from those questions to some more pleasant ones. Ms. Rivera, can you tell us why you are running for judge?
Yes, I have been a practitioner for 12 years. I had the opportunity to represent a lot of clients and have an impact in their lives. I wanted to do that on a greater scale and serve my community in that way. And I think it's important for the people that come before court to understand their rights, to understand what's going on. Especially in the county civil arena, a lot of the litigants are unrepresented, and I think it's so crucial that they be educated on the rulings and why the things are happening to them, and whether the decision goes in their favor or not. It's an easier pill to swallow if they walk out of there a little bit more educated and more empowered.
Absolutely. Mr. Finch.
I'm a 21-year practitioner, and I've only represented citizens and businesses. And in that 21 years, I've learned a lot about the law. I've learned more about people and the effect of the court on people. We're there every day, most days. They're there infrequently, and it's a scary thing. It's not, they don't want to be there, they don't understand it, and they have a problem that has to be resolved. I believe that my knowledge in very broad areas of law, I've done divorce, landlord, tenant, criminal, a broad spectrum of law. I think that knowledge, coupled with my integrity, my honesty, and my respect for other people, would be a benefit to people that come before the court. All the courts in Seminole County have a placard that says professionalism demands courtesy. And it's pointed out toward the people who come before the court and the attorneys. Well, I believe it should be pointed the other way also. I think a court needs to have respect and courtesy for the people that come before them, because it is a scary process. They need to understand it, to be able to live with it, a negative decision or a positive decision. They're better able to live with it if they've been treated with respect and courtesy. They'll feel the fairness more of it. And I believe that with my skills and my experience and my life experiences, like the bankruptcies you mentioned, has allowed me to identify with people, understand their problem, and be more fair in my outlook on how I would have to apply the law to resolve the problem they couldn't resolve for themselves.
And Judge, why are you seeking to keep your seat?
Much for the same reasons that these candidates have expressed. I enjoy my job, and I think I make a positive impact on the citizens and the litigants that come before the court. Every litigant deserves a experienced, knowledgeable individual presiding over their case. It's an important role. It could be one of the most important elected positions that the voters will ever choose upon. And I've enjoyed my role as a judge as I did as an attorney, and I enjoy the law, and most importantly, I enjoy serving my community.
Mr. Finch, have you run for political office before, a judge's seat or any other office?
No, I have not.
Okay. Ms. Rivera?
No, I have not.
Okay. And Mr. Finch, have you applied for any openings, vacancies on the court?
You mean for appointment? I'm sorry.
Yeah, for appointment with the JNC. Have you submitted an application for any vacancies with the JNC?
No, this is my maiden voyage into the political process.
Okay. Ms. Rivera?
I initially applied for an appointment position in Orange County, but after some thought, it wasn't my intention to uproot my family to Orange County, and presented with the opportunity to run for election in Seminole County. That's what I chose to do. So other than that initial application, which was ultimately withdrawn, I have no ventures into political office prior to that.
Okay, I guess one question I want to ask is this. Judicial temperament is an important thing for a judge to have. And Mr. Finch, we want to know how you would convince voters that you have the proper temperament for the bench.
Well, I'm a 40-year Seminole County resident. I know a lot of people in Seminole County. I grew up here, went to school here. I graduated from Rivera High School. A lot of people know me and already know that I have the patience of an oyster. I understand that the problems that are brought to the bench are problems not for the bench, but for those people. A judge simply doesn't have any right to get mad, to be impatient, to be rude, or discourteous. They're just trying to create a forum for people to resolve their problems. If they can't resolve it themselves, then you have to be calm yourself and be judicious and reasonable. My campaign motto is just that: keep calm and vote. It's a scary process, but it's not scary for the judge. The judge is up there every day, and the judge just has to take time to sit back and understand that they're not up there every day. And when you set yourself apart from it that way, it's easy to be patient and to show people that I am patient and that I have the temperament. My motto says it, and my personal relationships within the community have taught it over the last 40 years.
Ms. Rivera, same question.
I think my experience in the private practice speaks for itself. I did start my career as a prosecutor in sex crimes and child abuse, and obviously in that position I had the opportunity to work with many victims, parents, families, in a very sensitive type of environment. So you learn patience real quick, you learn sympathy and compassion very quickly, and put aside a lot of times the logistics, the legalities of a case to just be there for that person. In private practice, I had the opportunity to represent a multitude of clients, and for me, it isn't another client who has signed a contract and I do my job and walk out. For me, these people become part of my family and I become part of theirs, and they look to me for counsel and for guidance and comfort. And if it means that we spend a little extra time in the office or on the phone venting about what it is that troubles them, then that's what I'm there to do. That's the privilege that I've been given. And as a judge, I feel that, like Mr. Finch said, these people are scared. There's a lot of anxiety coming into a courtroom where they don't know what's happening or what's going to happen. Because at the end of the day, the judge gets to go home and live their life and do whatever it is that they do, but whatever decision they made that day is going to affect that person and that person's family as well. And you have to be cognizant of that always. And it's very easy to treat people professionally and respectfully and still do a good, efficient job.
Thank you. Judge Collins, how would you describe your temperament since you've been on the bench?
Well, I will tell you this, that judicial temperament is just not one thing. It's a combination of a lot of things. It can be a combination of decisiveness. It can be compassion. It can be firm. It can be common sense, humility. So when we talk about the judicial temperament, in my experience as a judge, some of what started out with some of my weaknesses have become my strength. I think that, like in any occupation, whether you're a school teacher or a firefighter or a writer, we become better the longer we do it. I think in the beginning, as a judge, what may have been perceived as direct came off lacking in tact and lacking in patience. And now, throughout my 8 years on the bench, I think if you were to ask me what one of my strengths are, I would say patience. So, and as a judge, you have to have patience, and you have to be a good listener. I always thought, as an attorney, I was an excellent listener. But it wasn't until you took the bench that you realized how hard it is to listen, to truly listen to both sides. And as a judge, you have to listen to both sides. And I understand that there's compassion, there needs to be compassion, but there must be fairness for both sides too. We can't be overly compassionate. We can't let our feelings get into the rulings that we make. We must always make rulings by the law. That is the cardinal duty of a judge, is to follow the law. And I agree with Ms. Rivera that some litigants, especially pro se litigants, will come into a court, and if they get an adverse ruling, they don't understand. They take it very personal that the judge is not on their side or has it wrong. And as a judge, you have to impart your orders in a way that they do understand with a certain amount of firmness, or else the courts would be in chaos. So I would say that probably the combination of humility, knowing that it's not your wishes or your desires or your opinion on the law that matters. It's the law itself, and being fair to both parties.
I wanted to follow up on that. You said that feelings shouldn't color the rulings that you make as a judge, and we were doing some research and we found something called the roving report, which looks at judges, and two things stood out about it. The themes that, the negative themes of this were that you were capricious in your rulings and that you let your feelings sometimes dictate how you ruled on a particular case. And the second thing was that you seemed to have occasion to give legal advice from the bench. And again, we don't know who wrote this because this is all anonymous and it could be someone with a hidden agenda, but could you address those 2 points?
Well, when you are a county court judge, you do have to instruct litigants on certain rules of civil procedure, or if they're unrepresented themselves in the criminal court. And some individuals don't want to be represented by an attorney, but they must follow the same rules that the other party follows. I can't go easier on someone because they choose to represent themselves, although they have a constitutional right to represent themselves. At the same time, we must be fair to both sides. I'm not familiar with the comments that you're referring to, but as a judge, you're going to make a ruling and someone's going to walk out of there not happy. And it may seem that my rulings were capricious, or to them, I don't know. I really don't know where that's coming from. But as far as instructing on the law, no, I'm prohibited from getting down and litigating from one side. But I do have to instruct them on the procedures as to what comes next and what should happen in their case. And if one party perceives me reaching over and helping another party, I would tell you that I would instruct that to the other litigants. Because as a judge in county court, especially in civil court, most of my litigants that come before the court are unrepresented.
Mr. Finch, have you ever been disciplined by the Florida Bar?
No.
Uh-huh. Ms. Rivera?
No, I'm not.
Okay.
Oh, I've had a bar complaint that went for a de minimis trust account violation. There was a deposit thing. It went to the grievance committee, and there was no probable cause found. Other than that, I've had grievances over 21 years, none with probable cause, but I've never received any discipline that I'm aware of. No.
Yeah, okay. And your answer was no as well?
No, I haven't.
Have you, Ms. Collins, have you ever had any discipline from the JQC?
No.
Okay. Can you, starting with Ms. Rivera, can you tell us the kind of cases you've handled as a lawyer that you would be, that would also come before you as a judge?
Yes, I have, big majority of my practice is in landlord-tenant law, dealing with evictions and security deposit issues, different matters dealing with landlord-tenants, and that is a large portion of the county civil docket, as well as small claims actions, breach of contract between contractors or neighbors or parties. So I have had ample experience litigating those type of issues in all the counties around Central Florida. As I said, I started my career with the prosecutor's office, and even though at this time the position is for the county civil, I did litigate multiple misdemeanor crimes in the prosecutor's office as well as criminal defense work.
Same question for you, Mr. Finch.
In my 21 years, I've done predominantly general civil practice, with much less criminal, though I do have criminal experience in felony and misdemeanors. I have federal court litigation, state court litigation. The thing I learned in all those cases is how you litigate's like learning to drive a car with a stick shift. The tools are all, that's the tool of how you get there. Once you learn how to operate a car with a stick shift, you can operate any car, truck with a stick shift. Well, that's what litigation is. Once you learn the rules of evidence, the procedural rules, how to give testimony, how to present, then you learn how to practice in all forums. Specifically in county court forum, like Ms. Rivera, I do a lot of landlord-tenant in Brevard, not as much in Seminole County. I do multiple contract actions, a lot of actions dealing with mechanics liens for automobiles and for construction liens. So I'm familiar with the court, the county court forum, and very familiar with litigating everything that comes out of into that courtroom, because I can drive a stick shift. It's the same thing wherever you go, just the amount is different. The people you're litigating against is different, and they have less of a knowledge of what you're doing, because half of them, or maybe probably more than half, are pro se litigants. But that's how my litigation's prepared me for a county position.
And Judge, what cases have you handled over your 8 years? What category of cases? Has it been the same, or have you switched around?
No, I've switched around. I was assigned to the criminal bench for 6 years, and now I'm on the civil bench. I've been on the civil bench for 2 years. And this position is both, this is a county court position, so you will handle criminal and civil cases. The majority of the cases that are handled in Seminole County on our civil judgeships are criminal cases, misdemeanor criminal cases. We also handle injunctions, domestic violence, repeat violence, simplified dissolutions of marriage, landlord-tenants, and as a county judge, you're responsible for first appearances, which then you would hear bond hearings and felony cases, a variety of cases. Does that answer your question?
Yes.
Okay.
Ms. Rivera, what kind of volunteer or community service activities have you been involved in outside of the courtroom?
I am a member, well, not a member, but I volunteer with the Guardian Ad Litem program. Most of the cases that I've done have come out of Orange County, and I've had the opportunity to represent some children, and have even seen some of them go to adoption, which was probably the best experience I've ever had. I also volunteer with my son's school, very involved in that. I also attend a local church and am involved with outreach programs there, programs that help families in need, and certainly with the children's program with Vacation Bible School and things of that nature.
Mr. Finch?
Well, until the last couple of years, I was a Pop Warner football coach for many, many years in the Seminole County, and for a couple of years in DeLand. I'm a member of a church, I attend church. And most of my community involvement is helping people. I do a lot of free interviews and consultations with people to assist them in taking care of the problems they have when they can't afford an attorney. In the last 2 years, I've not done a lot of that because I've been establishing a new practice.
And Judge Collins?
Throughout my years, I've been a resident of Seminole County since 1990. So I've been involved in many civic organizations, and outside, of course, when you have children, you're completely absorbed in your children's activities. So PTA and the booster clubs that's just, to me, I consider that just part of raising kids. And but I'm a member of Kiwanis, Sanford Kiwanis, which is, again, our mission is to help children. And I've been a long-time member. I was just trying to think how long I've been a member of Sanford Kiwanis, and I don't recall. It's probably been at least 10 or 12 years. And also a member of a local church in Seminole County. I was on the board of directors for Habitat for Humanity for many years, and that was very rewarding. I know I'm missing things. Of course, you wanted something not law-related, because I've been a member of the bar, the Voluntary Bar Associations in Williams and Support, but I consider that a part of my profession and something that we do as a member of the legal profession. I can't think. I know there's probably many more things, and I just can't think of it right off the top of my head.
Well, that'll do for now. Thank you.
Mr. Finch, why are you, often incumbent judges don't draw opposition. Why did you decide to run against an incumbent?
Well, one, I came to a decision that I wanted to be a judge. So I started looking at the races that were available, and the races where there was not an incumbent were circuit court races. And I didn't have an aspiration toward the circuit bench or beyond to a district court of appeal. I'm a 40-year county resident. I know the people of Seminole County, and I wanted to serve in Seminole County. The only two races that were available at the time was Judge Woodard and Judge Collins. So I chose to run against Judge Collins because I've been approached by people in the community who thought that my makeup, my experience, my fairness would benefit that particular seat in Seminole County.
Same question.
Well, I suspect that it's going to be along the same lines as Mr. Finch. Initially, when I had submitted my application for an appointment in Orange County and ultimately decided that I wanted to stay in Seminole County, it was because I had decided that that's the next level that I wanted to take my career to. And when I initially put in the appointment, I never thought that I was going to be able to run an election, or you have a preconceived idea of who has the ability and the resources to run for election, and I just didn't think I ever fit into that. But after speaking to people in my circle, it became a very real possibility. And again, there were county court positions and circuit court positions, and like Mr. Finch, I didn't necessarily have an aspiration right now, at least in my career, to become a circuit court judge. I feel like the county court position would be a good learning platform. You're dealing in circuit court with very serious issues and never been a judge before. I want to learn how to be a good judge, and like Judge Collins said, you learn more every day and you get better every day. And I think county court was a good spot to do that in. And evaluating the two positions, or the two open positions, I felt that I had the demeanor and the qualifications that were needed for this particular group.
And Judge Collins, why did you decide to stand for re-election?
Because I enjoy my job.
Ms. Rivera, can you think of any good ways to reduce costs in the court system today?
I think, it comes down to something as simple as there are certain matters that can and should be dealt with quickly, and you don't need to wait months for hearing time to resolve certain matters. And I spoke to another attorney who's been in Seminole County for quite some time, and he tells me a lot of stories of how practicing law used to be 30 and 40 years ago. And there was a lot of informal conversations, and attorneys would pick up the phone and talk to each other. The judges would call and get the attorneys on the phone and try and resolve a simple matter without dragging everybody into court, or without trying to find valuable court time to resolve a simple dispute that could be reserved for something more substantial. So I think because time is such a valuable asset, if everybody is working as a unit to try and resolve a case, get it litigated effectively without having to take up court time that needs to be for true legitimate issues, then I think that could substantially cut down costs. It would certainly open up the dockets more for other attorneys and other cases to be resolved.
Mr. Finch?
In defining what costs are, there's a cost to the court and there's a cost to the people who come before the court. The cost to the court, it's well documented that judges have lots of cases, stacks and stacks and stacks of paper. The e-filing that's been put in place is a good way to reduce that, and judges allowing e-filing into their offices, serving things to the judge by email and sending it back out instead of sending pieces of paper back and forth would be a tremendous cost. It'd be a cost savings, excuse me. There's a cost savings in setting times to get rid of, as I agree with Ms. Rivera, there are certain matters that don't take up much of the court's time and doesn't take up much of an attorney's time if you can set a time where all those things can run through. But that doesn't seem to be an available thing because it takes a long time to get a hearing in Seminole County and in Orange County and in every other county, waiting months and months and months and months for hearings because the important hearings or the longer hearings are being put off because you're having to deal with the other ones because there's no set time. I would, as a judge, I think I would shorten my lunchtime and give people 30 minutes, come and get orders signed, come in early in the morning. As soon as you're allowed to come in, get people to run. Those simple things to clear the docket out. As far as costs to the people coming to the courtroom, I think where those costs can be saved is by giving rulings that are well thought out, knowledgeable, not capricious, not in anger, understand, because each one of those rulings results in another hearing for rehearing or results in an appeal. As a part of my practice, I've done in excess of 60-something appeals. And that's just extra expense to the courts to deal with it. Not just this court, the people in Daytona. So I think in reducing the cost of the people coming into the court, good, fair, well-reasoned, just rulings that meet needs with a proper application of law will reduce a proliferation of litigation in each individual case. You don't want to make one case 6 cases. And I think that happens when the humanity of the process is substituted for a stack of files and docket numbers.
And Judge Collins, can you think of ways to save costs or ways that you have actually saved costs while you sat on the bench?
Since I've been in the on the civil bench, we have implemented, along with the clerk's office, we have implemented electronic filing and not only just electronic filing, but also electronic signatures for the judges. And that decreases the amount of time for the litigants, but it also helps speed up the time that I can get an order out. And those are important things. But one of the things I did when I went to the circuit, to the county civil, is I looked at what technology was available. And the past 2 years, I have reduced, through the technology and procedures that I implemented, I have reduced the caseload by 35%. And what that does is that allows the litigants who come before the court to have more access to the court, to get court time sooner than they would, because there's less cases on the docket. And that is a result of just cleaning the procedures in which we do. And does it save cost? I don't know if it saves cost. I mean, every judge I know works very hard. I don't take a lunch. I work through my lunch. And I've always worked through my lunch because there's just too much work. I mean, I don't know judges that don't work. And so cutting cost is always good, but I don't know how I would cut cost and still be efficient. And I know hearing time's an issue. I hear it all the time. You know, there's not enough hearing time. We have a county that last time I checked was 430,000 residents in Seminole County. It has grown tremendously in the past 30 years. And I too agree with Mr. Rivera. I talk to attorneys who've been practicing, 30 years, 40 years, and I would love to go back to that day where you could go and have coffee and talk about it and sit with your other as attorneys. But it just, we have 500,000 residents in Seminole County. We have one civil judge. It's, I'm trying to do the best I can to get everyone hearing time, return phone calls. So I don't really know how I would cut costs any more than just what we've already done.
Of course, when voters go to the polls on election day, they are going to see this as a choice between three candidates. So to voters, what would you say to convince them to choose you over the other two candidates?
First, I would, is that question
Yes.
directed at me?
Yes.
Okay. First, I would tell them to go to the Supreme Court website and look at our judicial voluntary disclosures. They can go to our websites and they'll hear how great we are and all the wonderful things we've done and what we will do and what our perceptions are. If they go to the Supreme Court website, they'll also see the bad and the ugly as well as the good, and to become knowledgeable about who you're voting for. Most people don't like attorneys, don't want attorneys until they need one. It's even more that way when it comes to a judge. They don't care about judges until they're standing in front of one. So in my campaign, I have encouraged everyone to go to the Florida Bar and see our disclosures, see what we've done, see what we're capable of. Because you don't want to be in front of a judge who's not capable of doing the work you need them to do for your particular case. Each voter is worried about their case, their life, and not the other 500,000 residents in Seminole County. So they need to become educated, and that's a great place to become educated. What would I tell them, and what will I tell them up until August 26th and maybe into November, is look at what I have done. I've been in the courtroom. There's not an issue in this race that any of us are not qualified to drive the stick shift. We know how to do that. But have we done it? Have we been up there? Do we have to learn the law anew for your particular case because we haven't done it before? So I would encourage them to look at what I have done. 21 years of representing people every day in their lives with their problems and their successes in various areas of the law, and trust that when you come before me, it's not going to be a new thing for me. There's very little in the law that's new every day. You go research it, you find where somebody else has had that problem, and you have a roadmap. I do that. I've done that. So when the voter comes before me, they're not going to get a ruling that's off the cuff, off the shoulder. It's going to be based on law, and they can learn consistent. Be guaranteed that I'm going to be consistent because I'm going to follow the law that's already been laid out for us before.
Judge, you next.
Could you repeat the
The
question?
question is, why should voters choose you over your two opponents?
Okay. anyone who comes to court deserves a experienced and knowledgeable judge presiding over their case. I have 8 years experience doing the job that I'm doing. I would encourage the voters to reach out to people in the community who they know regularly go to court. The attorneys, police officers, the clerks of courts are individuals that see judges work day in and day out. My reputation is one of fairness, firmness, and hardworking. And I would encourage them to, as Mr. Finch said, go to the voluntary self-disclosure at the Florida Bar, do their homework, talk to nonpartisan groups, read the Orlando Sentinel endorsements, whoever they may endorse. All these things are important to find out who their right candidate is. And I would encourage them to do that.
Ms. Rivera.
You know, I sympathize with the voters because of that very fact that there isn't a lot of information out there on judicial candidates. And for that reason, if people end up voting for somebody in a judicial race, it's usually for their own personal arbitrary reason, if they vote at all. Sometimes people leave them blank. So I understand that it's a difficult decision to make when there isn't a lot of information to base that on. But I think, you know, obviously the obvious ways to research that have already been mentioned here. Whether it's this interview or the Supreme Court, the Florida Bar, voluntary disclosure forms, or whatever interviews or forums that the candidates participate in that are open to anyone who wants to hear it. I think we all three of us have people that we could say, ask this person, ask that person, ask them what they think of my qualifications and my demeanor, and we'll all get positive responses from those people. But I think when at the polls, once you've done your research, you have to figure out what it is that you're looking for in a judge, should you ever come before that judge. What type of attitude, personality, what type of treatment do you expect to receive from that person? And does the person that you're voting for convey that to you? And I think that, you know, I can say personally that I do. I've litigated, I'm a criminal litigator, I'm a civil litigator. I enjoy being in the courtroom. I understand the courtroom procedure. And not every attorney, not every judge is going to know everything about the law. It is constantly a revolving door of information, and you're constantly learning. But I think what's important is to make sure that you're humble enough to acknowledge that and allow yourself to be educated. And that means reading all the pleadings that are submitted to you by the bar and giving them the respect of the time that they put in to create those pleadings before a hearing.
How are we on time, Paul?
I think we're probably about out of time.
Okay.
Thank you all for
Thank
coming
you.
in
Thank
today.
you.
Thank you.